So, good evening, everyone. I hope everyone is having a great Thursday. I'd like to thank everybody for joining us for today's webinar titled Your Right as a Llama Tenant. Today, our speaker will be David Hershey Webb of Hamilton, McConnell, Gribben, Donahue Joseph, LLP. He's an amazing attorney. He's well-versed in Llama housing, and he will provide the tenants today with the proper tools and knowledge. So, David, you can take it away.
Good evening, everyone. It's nice to be here. Thank you to Palante for inviting me. It's a wonderful group that does so much for tenants. So it's a pleasure to be here. What I'm planning to do is give you a brief overview. Although you're living in Llama housing, I'm going to give you a brief overview of the Llama program, and then talk about some of the issues that in my practice have come up for Llama tenants. I've been representing Llama tenants for 20 years now in all kinds of different cases, but I'm going to try to hit on some of the issues that I have seen come up from my clients, and maybe there'll be issues that are of interest, concern to you. So the Llama program goes back to the late 50s, in fact, and the idea was to incentivize or give developers an incentive to build affordable housing. And the deal was the city in some cases would give the developers the land. In other cases, in all cases, they would give the developers, once the buildings are built, tax credits. And in exchange for the tax credits, meaning essentially they pay lower taxes, in exchange for that, the owners were required to keep the rents below a certain level, and rent or sell, because some of the Llamas are rentals and a lot of them are co-ops like yours. Either and then the requirement was to either rent or sell to only to low or middle income tenants. So that was the deal. An issue has also written into the plan was that after a certain number of years, some of the Llamas, the ones built after 1973, after the end of 1973, could leave the Llama program if they met certain conditions. So you may have heard of privatization that's happened in a number of buildings. If they paid off the mortgage, they're able to go out of the Llama program and become private co-ops or private or rentals. If it's a building built before 1974 and it's a rental, those apartments would go into rent stabilization. So that's pretty much the overview. In order to get into a Llama, as you all know, because you had to go through it, you have to sign up on a waiting list. Sometimes the waiting list can be 10, 13 years before you actually get offered an apartment. When you're offered an apartment, you have to meet certain income requirements. Your income can't be too high to get into the Llama. And there's also certain occupancy requirements to get into one studio, one bedroom, or two bedroom, depending. Once you're in to the Llama, the kinds of issues that I see come up are you have to, one of the most important things is similar to in rent stabilization, you have to maintain your apartment as your primary residence. And that means you're not living elsewhere. If you're not actually living in the apartment, that's grounds for termination of your lease. And that comes up a fair amount. If the housing company or the landlord suspects that you're not actually living in the apartment, then they can commence a case against you, and then you will have to prove that you're actually been living there, and the types of things they will look at to prove that is that you're filing your taxes there, that your driver's license is there, your credit card, your bank statements, all of your documents, and that you're physically present in the apartment. That doesn't mean that you can't, if you're fortunate enough to be in this position, you can't own another property. You can own another property, but you can't live there. I should say, by living in your apartment, there's also a requirement of being physically present there, at least more than half the year that you're actually sleeping there. So sometimes people go away for a month or two on a vacation or something, or you have relatives, that's permitted. But overall, you want to be living in the apartment, sleeping in the apartment more than half the year. So the other issue that's related to, I should add, related, that your name should be on the income affidavit every year when you file your income affidavit. So the other issue that comes up a lot related to primary residence is succession rights. And I'll tell you, at the moment, I'm probably handling maybe 20 succession cases in HPD Mitchell Lamas. And I've handled, scores throughout the years. In order to succeed, meaning to take over a Mitchell Lama apartment, these are the requirements. You have to have lived as your primary residence, as I just described. Live as your primary residence with the head of household, the shareholder and the head of household, live in the apartment in general, it's for 2 years immediately before the primary tenant or head of household either moves or dies. So you have to live, in fact, co-occupy, meaning that the tenant has to be living there and you have to be living there. You cannot file for succession until that tenant either leaves or dies. That's when your right to succession comes up. Number two, you have to be an immediate family member of the tenant, or what's called a non-traditional family type relationship, which say you may be a couple that never got married. You may be a relative who you think of as a father or a mother. There are ways to get succession even though you don't have an immediate family relationship. And not every family relationship counts. I'm not going to go through the entire list, but it's mother, father, son, brother, sister, in-laws, aunts and uncles, nieces, nephews, not cousins. So not every family relationship. I should add, you should always be on the income affidavit if you want succession. If for some reason you were not on the income affidavit, it's not always fatal. I was the one, I'm happy to say, I went to the Court of Appeals, the highest court in New York State, and got them to change the rule to say that if you're not on the income affidavit, it's not going to be fatal to your succession claim. That doesn't mean it's a good idea, but if you, in some cases, you could still get succession. If you are either 62 years or older or disabled, then the period that you have to show co-occupancy is only 1 year. Now I'm talking about the person seeking succession, not the tenant. The tenant often tends to be older, but the person seeking the succession, if you are 62 or older or disabled, you only have to show 1 year rather than 2 years. So how do you show that you have resided in the apartment for the required amount of time? The most important document that the housing company and then eventually HPD will look at is your tax returns. You have to file tax returns in New York State at the address that you're seeking succession to for those years that you're claiming you were living there. That's the most important. And as of yet, even though I was happy to win a case where my client was not on every income affidavit, there's no court decision I know of that's given succession to somebody who filed taxes at some other address. You have to file where you're living. Now, if your income's too low and you don't file taxes at all, you may still get succession, but you can't file them anywhere else. The other documents that generally a court or HPD or the housing company will look at will be your driver's license, your credit card, your bank statements, where you vote. Very important where you vote. Those are all the types of documents. And now they'll look at those documents not only for you, but for the tenant, because the tenant has to be there also. You both have to be there together. So that's the succession. You can't file it until after the tenant leaves. The fact that you're on, if it's a co-op, Tracy Towers, rental or a co-op? Oh, your phone is off, but I'm not sure.
Muted, Jakari.
Yeah, you're muted, but
I'm not.
you're not sure. Okay, I know. I can look it up. I should know. But I'll find out. What I was going to say though is if it is a co-op, being on the stock certificate is not going to get you succession. Thank you. Someone answered. Yes, it's a rental, so never mind about the stock certificate. There are a lot of Llama co-ops. I've been dealing with a lot of them. So that doesn't. Rochdale is a co-op. Somebody's telling me. So a lot of them are co-ops, but Tracy Tower is not a co-op. So the issue of stock certificate is not an issue at all for you. But everything else I said is valid for your building. I'll say 2 or 3 other things, and then I think I'm almost ready to start answering some questions. Let me say something about transfers. If you're looking to transfer from an apartment to another apartment, you have to meet the occupancy requirements in order to transfer. That wasn't always the case, but you have to meet the occupancy requirements for the type of number of bedrooms you're seeking to move to. And I have them somewhere here. I don't have it off the top of my head. So if someone asks specifically what the occupancy requirements are, I'm going to have to find my documents. But in terms of the income affidavits, and maybe people have experienced this, but you have to file every year. You have to answer honestly. They're signed before notary under penalty of law. And if you don't, you can run into trouble. If your income exceeds a certain amount, and I'm sorry to say, it's also something I would have to look up because I'm not 100% sure what the amount is. If your income exceeds a certain amount, you can be charged a surcharge, which is a higher rent, which I believe is about 50% of your existing rent. I believe that's the maximum surcharge. So if your income goes up too much, you're not thrown out. You don't lose the apartment, but you have to pay more. There may be provisions in the regulations that say they could evict people for having too high an income, but they have never in 20 years ever done that. I don't expect them to. So that's transfers. The waiting list, I don't know, we need to talk too much about that. There is an internal waiting list for transfers, and then there's an external waiting list for people who are trying to get into the building. And they choose a certain number of people from the internal waiting list, and then the external, they go back and forth, but the internal waiting list takes precedent for transfers. I talked about the income, the internal. the internal waiting list gets preference. So what they do is they pick, I believe, I'm not 100% certain, they pick maybe 2 people from the internal, and then 1 from the external and 2 from the internal. I'm not exactly sure. But the internal gets preference. There are other preferences. There's preferences for both for internal and external. There's a veterans preference. There's, I believe, there may be a homeless preference, people coming from a shelter or something for external. There's some other, those are the main one is the veterans preference, although they're threatening in the state Mitchell-Lamas, in the city Mitchell-Lamas, they're threatening to do away with the veterans preference. They're trying to, but they haven't adopted it yet. So there are the waiting list is a very complicated area, and I'll do my best to answer questions about it. But they are, over the years, they're trying to be more transparent. I don't know that they've actually reached the level of transparency that they should be at. My understanding is they're supposed to post the waiting lists in the management office of every Mitchell-Lama. I don't know that they're actually doing that. And I'll be honest, I don't know if it's in the regulations or a policy. I'm not sure, but my understanding was they're supposed to do that. They do a lot of the waiting list stuff, as you probably know now, online through something called Mitchell-Lama Connect. And if you're on a waiting list, you can go on and see where you are on the waiting list. But there are issues about transparency of the waiting list, and I think that's going to become more and more of a battle, because sometimes people get moved around. It's not clear why they did, why their place went from number 100 to number 200 overnight. There's things that happen with the waiting lists. I think the last thing I'll say, HPD is the city agency, Housing Preservation and Development, that supervises the city Mitchell-Lamas. I'm not, they do an okay job, but they could do better, I think. Everybody could do better. There's a lot of corruption in the Mitchell-Lama system by everybody, by management, by tenants, everybody. I'm not saying everybody, but there's a lot of corruption. One of the problems with the fact that there is corruption is that if you have a valid claim, a valid succession claim, sometimes HPD will give you a very hard time, because HPD is very skeptical of everything, because they see people trying to get by on things, and so they scrutinize things. But there is corruption, there's favoritism, there's all kinds of problems, And the best thing is to be organized, as Palante will tell you, be organized as best you can, so you're not fighting battles as a single person, but as a group, and trying to keep things honest and straight, and make sure your rights are being recognized and addressed. So that's what I have to tell you. And I'm happy to start answering some of the questions.
Sure. We have a few that came in, and we'll see if some more come in as we start to go through them. First one that I think showed up was, do you have any regulations regarding tenants disturbing other tenants?
Well, oof. I will tell you this. I would look to, in the Mitchell-Lama regulations themselves, the only reference would be there probably is a reference somewhere to objectionable conduct, which is a broad term. In any lease, in any building, if you are found to be engaged in what's called objectionable conduct, disturbing your neighbors, excessively disturbing your neighbors, making it impossible for your neighbors to enjoy their apartment, that can be the basis for an eviction proceeding. And there's 2 types of proceedings. It could be brought as what's called a breach of lease proceeding, which is a violation of the lease that you can cure, meaning stop doing what you were accused of doing, and you'll keep your apartment. The harder situation is where they bring a case on what's called a nuisance theory, which means it's ongoing conduct over a period of time that cannot be cured, cannot be fixed. In that case, if a court found that you were engaged in nuisance activity, you could lose your apartment and there'd be no cure. I haven't seen this much I haven't seen it much in Mitchell Lamas, and I will tell you, as a tenant firm, because my firm only represents tenants, although we do represent a few co-ops, but do no evictions. We only do general contract matters and such. But since we're a firm that only represents tenants, we don't take on tenant versus tenant cases. If someone's being threatened with eviction for something, we might take that on, but we don't take on something where your dispute is with another tenant. But everyone is entitled to a habitable living space.
Can you explain succession rights for family member to acquire apartment in HCR development?
Yeah. Well, it's the same. So HCR is stands for Housing and Community Renewal. It used to be called Division of Housing and Community Renewal. I think it might be Homes Community Renewal. That's some new name. But anyway, it's the state agency that oversees state Mitchell Lamas. So you have state Mitchell Lamas, which are overseen by HCR, and then city Mitchell Lamas, which are overseen or supervised by HPD. So the succession rules are the same in both. The succession rules are the same. For a family member in HCR or a family member in HPD, you have to have the things I discussed before. You have to live with the tenant for either 2 years or 1 year if you're 62 or older or disabled. The tenant has to live there and you have to live there. And then you have to prove that you live there, mainly with your taxes, your credit card, your bank statements, your driver's license, your voting, all those things they ask for. When the tenant leaves, only when the tenant leaves. So that's and then you have to be a family member, or what I call non-traditional family member, that you have some relationship that's as if being a family member. And then there's different rules. I don't know if anyone wants me to address at some point. There are different rules if you're a non-traditional family member, but let me see if there are other questions first.
Yeah. Does the board have the right to have meetings with no participation of shareholders? Rochdale Village.
Excellent question. And let's see if I know the answer, because that's a good question. What I will ask Jakari, maybe, if someone to get the questioner's contact so that I can answer the question with more certainty. I will. Let me tell you as a general matter that a co-op board can meet in private. So generally, I would say that is the case. A co-op board can meet in private, at least on some occasions. On the other hand, the shareholders, there are meetings that are required to be open. There's an annual shareholders meeting that's required to be open to all of the shareholders. There may be some board meetings that are required to be open also, and I don't know for sure. The answer would be found, well, there are two places. The answer is found in the Business Corporations Law, which regulates co-ops, and also found in the bylaws of Rochdale, of a particular co-op. Every shareholder, I will add, every shareholder is entitled to review the documents I believe, although I honestly will double check, but I'm fairly certain that every shareholder would be entitled to review the minutes also of meetings. So there is under the Business Corporations Law, there's an entitlement to review documents related to the co-op, the finances of the co-op. I believe the minutes, although maybe not in all cases. I'm not 100% sure about that. And of course, the bylaws, you're entitled to have a copy of the bylaws and the certificate of incorporation. So there are a lot of rights that shareholders have. I'll just say one other thing about that. The bylaws will also specify when the board can meet and how they can meet, whether they can meet without shareholders, I'm not 100% sure. I believe they can, but I have to, I'll get your information, get back to you on that.
Yes, whoever did ask that question, please feel free to contact, reach out to the organization. And I have a 2-bedroom apartment because my son used to live with me. Can they now force me to move to a smaller apartment?
Great question. Great question. The general answer, the theoretical answer, I mean, in terms of what they have the power to do is yes, they do. They have the right to ask you to move to a smaller apartment. Now, the practice up to now, up to the present, has been that rarely, if ever, happens. I'm not going to say it never happens, but very, very, very rarely happens that they downsize people, but they do have the right to downsize people. Here is one of the arguments, and I know, I believe Borough President of Manhattan, Gail Brewer, got involved in this issue when it came up in Manhattan, and there was pushback from her office on Mitchell Llamas that wanted to downsize people. Here's the issue that comes up. There's a lot of research. There's a certain amount of research that will say that for elderly people in particular, and I'm sure it doesn't apply necessarily to every elderly person, but for elderly people to have to move from your home of many, many years can be very traumatic, and it's not recommended. Let's say that. So that's one of the reasons we were able to push back on that. There's also the argument that some, and I don't know, this may or may not be your situation, or maybe someday it will, hopefully not, but there's also issues. Some elderly people need to have home health aids they need, or so there's arguments you can make to avoid downsizing if it comes up. I did have at least one client that they tried to downsize that I believe we successfully fought against, and she was not downsized. As I say, from what I have heard, it's fairly rare, but it's not impossible someday that they'll try to do it more because there's thousands and thousands of people on waiting lists. So you see, there's an argument for downsizing people, but there are arguments not to also, and currently I believe it's not being done very often.
Do you need approval from the board to organize with a group of cooperators?
Great question. And the answer is you have the right to organize. You have the right to have a tenants association or a cooperators association. There are certain rules that govern how you can do that, and they're found in the Mitchell-Llama regulations. And for some reason, over the last 20 years, the question has never come up for me. So I don't know what the specific rules are, but they're found in the Mitchell-Llama regulations, which you can find if you Google Mitchell-Llama regulations, either DHCR Mitchell-Llama regulations or HPD Mitchell-Llama regulations. You should be able to find them. I believe they're posted on the HPD website also, and on the DHCR or HCR website. And there's a whole section there on the right to organize. At least I've been told that. I haven't read it yet. So I think it's a good idea. It's always a good idea, as Palante will tell you, I'm sure. It's always a good idea to be organized. You have power as a group. As an individual, you're vulnerable, more vulnerable as an individual. Power comes in numbers. You can share information. You have more pressure. You get electeds involved easier. There's just so much. You know that.
What are the rules for a non-traditional family member?
Good, great question. So the doctrine of non-traditional family member succession was adopted by the courts in the Llama in the rent stabilization context in the 80s. It was 88, or I believe it was 1988, and it originally involved a gay couple who, of course, in 1988 could not marry by law, were not allowed to marry. And there was a lawsuit, I believe, or no, it was a case anyway, a case where this couple made the argument that succession, it's discriminatory for succession to only apply to married couples. And the law was adopted. First, there was a court decision, and then the DHCR at the time adopted regulations. Actually, the case went all the way to, I believe it went all the way to the Court of Appeals, the highest court in the state. But eventually regulations were adopted that said if you're a non-traditional family relationship, you can get succession. So it's extended way beyond gay couples, of course. So what the rule says is if you have to have emotional and financial interdependence in the same way that a family member would have. The emotional aspect of that is the easier of the two. And some of the criteria that specifically listed in the code and in the Llama regulations are that you share holidays and birthdays together, that people in the community recognize you as being like family, that you, those are the two main, if you're sick, your partner or the person who's like a father to you or like a son to you, take care of you. Those are the types of things you want to show. You have photographs. You take vacations together. That's actually listed as one of the criteria. These are all just ways for the court to be convinced, or for you to convince a court or a housing company that you have the same type of relationship that a father and son or a sister and brother would have. The harder part in some ways is the financial interdependence. And that means that you share expenses, but in something more than just being roommates, that you buy things for each other. If someone got sick, you may pay that person's medical bills. Those types of things. It's got to be something more than just being roommates where you're splitting the costs, maybe you help put someone through college, that kind of thing. So that's the financial interdependence. Now, there are a number of documents that they'll look at also to prove this kind of relationship. Do you have a joint bank account? Is the person you're claiming a family member? Does that person have a health proxy? Do you have a health proxy for that person, which means you give them the right to make healthcare decisions for you? Is there a power of attorney? These are all legal documents that would show that you have a relationship that's like a family relationship. Now, look, the laws do the best they can. It's not perfect. I mean, it's always humorous to me because there's many people who are actually family members that have none of these things. So, but the law they had to come up with some kind of rules, and those are the rules. So you want to be able to show, ideally, you have a joint a bank account, or health proxy, power of attorney. Was a person named as a beneficiary in your will, in a life insurance policy? Those are some of the things that that they'll look at. And of course, you have to meet the same co-occupancy requirements. I should add the length of the relationship as another factor. So if you've known each other for 20 years and you have this uniquely close relationship, even though you're not married or you're not actually father and son, or mother and daughter or whatever, the length of the relationship can also matter. So.
If you are the aunt of the tenant, can you get succession rights in a city Mitchell Llama?
Yes, absolutely. And I will tell you that in rent stabilization apartments, you cannot get succession. Sorry. So under rent stabilization, the landlords were successful, I think in the 90s, at getting the legislature to take aunts and uncles and nieces and nephews out of the succession provisions. In fact, we should have put them back in 2019 when we rewrote the rent laws. That just occurred to me. But on the Mitchell Llama, so far, they have not taken them out. So yes, an aunt can get succession from a niece can get succession from an aunt or an uncle, a nephew. Yeah, those relationships are still in the regulations. Yep.
All right, so we have a few more that came in. What about if you live with your dad, then he passes away, but I've been living with him for a long time? What will happen to me?
Yeah, and you have the right, if you've been living with your father for 2 years or more, and that's where you've been living, or 1 year if you're disabled, then you have the right to take, or 62 or older, but then you have the right to succeed to the apartment. Now, yeah, I don't know if there was an issue. I'll throw this in there. I thought I maybe read that this was a part of the question, but I have had, you can also get succession to an apartment if you're underage, if you're a minor, and your parent dies, or you can also get succession as long as there's a legal guardian that would be able to live with you. So that I've had that case also.
And our next question. If you are forced to downsize, do you pay the market value of the new apartment, or it's a later move? If you are a senior on a fixed income, that would be a hardship.
That's a good question. Well, first of all, nobody pays the market value in a Mitchell Llama, and at least that's how it's supposed to be. But I suppose it's possible, depending what the market is in your area, that you could be paying a market value. But the rents are set. The rents in the Mitchell Llama are set. The one, 2, 3 bedroom rents are set. It's a little different in a co-op. If it's a question of a co-op, you pay something called maintenance rather than rent. Even then, you shouldn't pay more than whatever the normal 1 bedroom or 2 bedroom, whatever it is, rent or maintenance for that apartment. The thing that does come up in a co-op is that when you buy into a co-op, there's a cost to buy in, and that's known as your equity. And some of the co-op apartments, since the value has gone up over the years, sometimes if you transfer in a co-op, they're now asking you to pay more additional money when you transfer, because the apartment you're moving into is a higher value than the apartment you're moving from. So that has been an issue for some of my clients.
I
But if
live.
you're downsizing, if
Mhm.
you're downsizing, the rent should be lower.
I live at Tracy Towers, which is a rental, City Mitchell
Right,
Llama. How can
right.
this convert to a co-op?
Ah, that's a fascinating question. Which look, number one. Well, I guess the first question is, was Tracy Towers built before or after 1974? And if you don't know, if you know the answer, tell me. If you don't, I'll try to look it up.
All right, so
So
we'll move on. Mhm.
yeah, 'cause I had it here. Tracy Towers, blah, 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 history, blah, 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 blah. The buildings were completed in 1972.
Before.
Yeah, and opened in 74, but completed in 72. So the main way that could happen would be that the current owners pay off whatever mortgage is on the building. They may have to, that's the main thing, pay the mortgage on the building. And then the apartments would go out of Mitchell Llama and into rent stabilization. Because the building was built before 1974, the building would then go into rent stabilization. Once the building is in rent stabilization, they could theoretically convert it to a co-op. Now, the only problem with doing that right now is that, as you might recall, in 2019, or I should say in 2018, the pro-tenant Democrats took over the New York State Senate. And the upshot of that, thanks to a lot of organizing by a lot of people over many, many years, because that's the only way you get anything done is by organizing. Because the Democrats, pro-tenant Democrats were able to take over the state Senate in 2019, New York State passed the most wide-ranging and progressive and pro-tenant laws ever, probably anywhere, at least since the 30s or 40s. One of the upshots of that is that whereas you used to have to, in order to convert a building from a rental to a co-op, you used to have to get 15% to sell, find people willing to purchase 15% of the apartments. Now you need 50%, 50%, people willing to purchase 50% of the apartments. The real point there is that co-op conversions now have become, and there are other restrictions, but co-op conversions have become very, 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 very difficult. So unless the law changes again, I don't expect a lot of co-op conversions, and I certainly wouldn't expect the co-op conversion in a building that's 100% rent stabilized. I don't see how that would be doable. So that's the answer.
Many cooperators disagree with the board and management of not changing the pipes when installing new convectors. Where or whom can the cooperators go to for advice on this matter? The building are almost 60 years old in the past, and now we have had leaks from these pipes.
Oh, that's a tricky one. Look, the decisions about capital improvements are going to be made by the board in consultation with management and with HPD. If the shareholders disagree, as in any co-op, the best answer, as difficult as it is to replace the board with people who have the differing view. Other than that, I'm not certain what your remedy would be. Certainly, as with any maintenance or repair issue like that, you ultimately may need your own architect or engineer to issue an opinion that they're doing it the wrong way, or they're doing it in a way that's not economically feasible or not the best practice. So if you have your own expert, then you could use that to either to go to the board, to go to HPD, to go to the management company, and to challenge what they're doing. And there may be a way to challenge it. At the end of the day, the best way is to put your own people on the board. But so that's what I would say. Get your expert so that you can make the argument. And then, you know, I always say use everybody. Use elected officials. Use a lawyer. Hit HPD. Hit the board. Hit the management company. You know, you use everything you got, and organize as many shareholders as you can. So, my answer.
How can a cooperator ensure that the board and management are following DOB and city council laws?
Boy, well, as far I mean, that's an interesting question. I think you have to find out from DOB what the regulations are, what the specific issue is, what the regulations are, and then, I mean, the DOB website is open to the public, and will list every permit that's been issued, every application for a permit that's been issued. That's all public knowledge, so you can find out what a board or management company has submitted to DOB. In terms of the type of work they're doing, and then you go back to the expert issue. It really depends on the specific issue. You need a way to ascertain, maybe with your own expert, what they're actually doing. And as I said before, you have the right as a shareholder to request copies of documents from the board, from the management company, copies of financial statements, copies of contracts, possibly copies of, I'm not 100% sure what the contracts, but I would argue you should be entitled to review them as a shareholder, copies of contracts. You can ask HPD to audit the board, the management company. They're not always as helpful as they should be, but so.
Is it right that a tenant can do whatever disturbance he or she wants to do during the waking hours until 10 p.m.? This assertion was made by a receptionist at a management office.
That's almost a rhetorical, that's like what we call a rhetorical question. No, it's not right. No, of course it's not right. A receptionist in the management office, yeah, no, these people, you know, there's better and worse, you know, they'll say anything. I mean, I don't want to sound too cynical, but management company employees, property managers, I mean, there's just, I just hear nightmare after nightmare. So they're not always well trained. Sometimes they're lying. I mean, I'm telling you from a tenant lawyer perspective. Sometimes they're lying. Sometimes they're just not trained. Sometimes they don't know anything about anything. There's all kinds of things. But as I said before, you have a right to what they call useful enjoyment, peaceful existence in your apartment. On the other hand, there's court decisions that say if you want a kind of bucolic, you know, country quietness, then you don't live in an urban environment. There's a lot of, for better for worse, there's a lot of toleration in the courts for noise. Now, is there a limit? Of course there's a limit. Of course there's a limit. You're playing your stereo at the top volume at midnight. That's a limit. That's a limit. Now you can call 311. There's a noise complaints you can make. I don't know how effective they are. They have to come out and measure it. You can hire your own noise person. There's a company called Acustalog. I'm not endorsing any particular company, but that's just a company that I know of. They'll come out and do measurements for you. If the noise is exceeding the legal decibel level, because there is a legal decibel level, then there's an issue. They could issue a violation. So, I mean, I honestly believe that you know, tenant versus tenant issues should be try to find a way to work it out, because you don't want to end up in court against a neighbor. It's you can't always work it out, but try to find a work. But no, the receptionist's wrong. She's wrong. I don't agree with it. Tell her to call me.
What is the procedure for changing the bylaws?
Wow. Well, the procedure for changing the bylaws is in the bylaws. So you have to get a copy of the bylaws, and you can find the procedure to change the bylaws. It involves some vote. I believe it should involve some vote by the shareholders, and that would be specified in your particular bylaws. It'll say exactly what you need to do.
What about the succession rights for a child under the age of 18? Can the other parent who's not on the income affidavit can ask for succession rights, so to not move the child, the child is on the income affidavit. Would the child have to show the same proof as an adult, especially if they are under the age of 18 and not claimed by the parent in the apartment?
Well, the question, I have to disentangle the question a little bit.
Right.
I mean, look, as I said before, yes, and maybe the moderator can help me with the question, but yes, a minor can obtain succession as long as there's a legal guardian to take care of the child in the apartment. I do not believe the legal guardian would have to be there at the time the succession was gained. I'm fairly certain that the legal guardian could come in after the child got the succession if the original tenant had left or died or something. So I'm not sure if that answers the question.
We'll wait for a possible elaboration on that one. And we've got a question coming up in Spanish. So if you want to hear that interpretation, stay on the English channel. One moment. Hola, mi pregunta es, yo vivo en HUD y pagué una deuda atrasada de mi renta y desde diciembre y lo estoy pagando de nuevo. Tengo mis recibos de la renta.
I'm not sure what the question is.
All right, so we'll wait for an elaboration on that one. As a follow-up to a previous question, the same question for a rental: how do you get pipes fixed if tenants are having a lot of leaks?
Well, it's the job of the management to fix the pipes. Ultimately, the tenants could, if the work is not being done, the tenants could get together and file something called an HP action, stands for housing part action, in housing court to force the management to fix the pipes. That would be a last resort. I would start with putting together a group and asking to meet with management and setting forth your demands that the pipes be fixed, that they provide you with what's called a scope of work and a schedule for when the pipes are going to be fixed. And if you don't get anywhere with that, then ultimately you do have a legal remedy of going into housing court on what's called the HP action, where a judge can order the landlord to do the work that is necessary. I will say that, if there are leaks, you should call 311 to put in violations, because you always want to have a record. Anything that you're complaining of, you want to have, a documentary record of. You don't want to end up in a he said, she said, or she said, or he said, or they said, he said, situation. You always want to dot your I's, cross your T's, have a record. So calling in a violation could be a record. If HPD comes out, and it's a different division of HPD, comes out and does inspection, bring in your own expert if you have to. But ultimately, there is a way to get relief in court, if that's as a last resort. Now, I should say that you have to be aware that if there is what's called a major capital improvement in a Llama, and all the pipes are replaced, because they have to be replaced, that you may get a rent increase. So you need to be aware of that. Now, look, if they have to be fixed, they have to be fixed. I'm not saying that as a reason not to push for it. You can't live with leaks. So, but you should be aware of that. People used to think, understandably, that if an owner puts off maintenance and then is forced to do the maintenance, that he can't get a rent increase. But that's not the law. If an owner does what's called a major capital improvement, replaces a roof, replaces all the windows, replaces the pipes, replaces the boiler, those types of things, he could get a rent increase. And in a Llama, he has to put an application into HPD. You have an opportunity to oppose it, so it's a whole process. But that's and it used to be in Llama, and I'm not sure where it is right now, that it would only be you would pay for the improvement, and then that charge would drop off. I'm hoping that's still the policy. In other words, once you finish paying for it, you don't pay for it anymore. But I'm not sure if that's still the policy.
And then I think the follow-up or clarification on that
Yeah.
other longer question that you were trying to disentangle was, what proof does the child need to show to obtain succession?
Sure. No, that's a good question. That's a good question. And it is hard. It is hard for minors. Obviously, a minor doesn't file taxes. Although I suppose if the tenant filed taxes and listed the minor as a dependent, that would be one way to show. When I've had these cases, the main thing that I've used is school records. I'm not sure that is obviously minors don't have credit cards and bank accounts and those types of things. So, but school records would show it. If the tenant or the parent or legal guardian filed taxes and the child is listed as a dependent, that would show it. Those are the main things I can think of. It's really going to be connected to the tenant. It's going to be connected to the child's guardian in the apartment. I think that child's proof of the residence is going to be connected to the tenant.
All right, so great. So we have just a couple more, and reaching the end here, but a real great line of questions tonight. I am wondering if I could get an apartment in your houses. I am 69 years old. I have been looking for an apartment for many years.
Excellent question. So, I mean, it sounds like the question of looking for an apartment in Tracy Towers. So, every Llama has a waiting list. They're not all open. Some of them are closed. But the best way to find out what is available is there's a website called Llama Connect that should have a list of waiting lists. If you are not computer savvy, or if you're not comfortable with computers, I would go to a group like Palante or another neighborhood group. Metropolitan Council on Housing is a tenant rights group like Palante. I know Palante does more than tenants' rights, but there's a group called Tenants and Neighbors. Those are two tenant advocacy groups that will be able to help you find the waiting lists for the Mitchell Llama buildings. At Tracy Towers, I don't see why you couldn't also just walk into the management office. Although, as we said, some management, people are more friendly than others, but you should be able to walk into the management office and ask them, do they have an open waiting list? But I have to tell you, the waiting list, most waiting lists at Mitchell Llamas, unless it's maybe most waiting lists, it's a matter of years. Not all of them. I have seen some that are shorter than that, but I don't. You have to find out. But it's very possible Tracy Towers waiting list, you could get on it, but it's going to be years. I would say, given your age, you should also talk to housing advocates about senior housing options. And there is at least one Mitchell Llama that's specifically set aside for seniors. There might be more, but I believe there is one. So there are a lot of different housing options.
Since weed may become legal, what rights do tenants have if the smoke affects them?
I'm gonna say, okay, give me a moment while I know. Look, that's a very, very good question. It's a very good question, an excellent question, because we have this issue with tobacco smoke, and the courts, the courts have said in at least a couple of decisions that since smoking tobacco is legal, then you're permitted to smoke in your apartment. And so you're anticipating the problem here, that if smoking weed it becomes legal, you'll be permitted to smoke in your apartment, and that could be a problem. This is a very, very difficult issue. It's a very difficult issue, and the best I can say is there's some level of smoke, whether it's tobacco smoke or marijuana smoke, some level of smoke that's going to be so intrusive that that you could find a court or that would tell that tenant they have to stop doing that, but I will say that in the tobacco smoke area, it's been difficult for people who don't want to smell that. It's been difficult, and I imagine in marijuana situation that's also going to be difficult. In private co-ops, the board can pass a rule that you can or can't do certain things. I don't know for sure in a Mitchell Llama co-op whether that would be possible. I doubt anyone's going to pass a law that says you can never smoke in your apartment. But it's a battle. It's a battle between the smokers and the non-smokers. And I'll say even before marijuana became illegal, personally, I smell it everywhere. I'm telling you, man, everywhere. Mm-hmm. For better or for worse.
If the majority board has a committee that decides whether or not a bylaw should be submitted for a vote by the cooperators, is that legal?
Oof. Well, I do not know the answer. I can tell you where the answer is. The answer is either in the business corporations law or in the bylaws of that particular co-op, because the bylaws itself is going to govern what the board can do and cannot do. Now, the business corporation law has some limits, but I don't, off the top of my head, I don't know. But I think the first place to look is the bylaws itself, which are going to say, should say whether a board can what the board's power is to present an amendment to the shareholders or not.
All right, well, that sort of brings us to the conclusion of the questions. A great, great set of questions that we got tonight. Thank
It
you.
was, it
And
was.
I'll give give it over to Jakadi for any
Yes,
final.
thank you. Yes, thank you, David, for giving us your time tonight and arming all of our attendees with such valuable information. We really appreciate it. I know everybody found that very extremely helpful. Also, thank you to Robert and Daniel, our interpreters. And thank you to all of our attendees for joining us. We will send out a follow-up with the applications for Llama housing and the recording of this webinar to everyone if you want to share it to others. And if you have any questions, please call Palante at 212-491-2541 or email us at palanteharlem.org. Okay, so thank you, David, again. It was a pleasure having you. Thank you for giving us such amazing information. So that will conclude tonight's webinar. Thank you, everybody. Have a good night. Okay.
Thank you.